according to me, Lord, as a student of law and as a citizen also, Lord, is something very, very serious. Other notable features, my Lord, by this CO, what was done? It provided for a separate provision for permanent residents of Jammu and Kashmir in Article 7. That is, my Lord, citizenship of Indian Constitution by inserting 35A.
Yes.
Then it removed references to scheduled tribes from Article 15, sub-Article 4. So, one, you alienate those who do not fall within the artificially created definition of permanent residence. Second, you alienate those who belong to scheduled tribe. Then, this is important. Article 19, 22, 31, 31A and 32 were applied with some modifications, and I'll show which modification. Surprisingly, in Article 19, please note this, my lord, this is something really shocking. And for 25 years, this continued. I am arguing this matter not from the point of view of center succeeding or state succeeding. How 370 operated on the people of Jammu and Kashmir. Because of 370. That's what, my lord, my attempt is. Surprisingly, in Article 19, the following sub-Article 7 was added by way of modification which remained till 1979, for 25 years. And what was that?
Yes.
Article 19, sub-Article 7, as applicable to the state of Jammu and Kashmir, the words reasonable restrictions occurring in clause 2, 3, 4 and 5 shall be construed as meaning such restrictions as the appropriate legislature deems reasonable. Lord, the citizens apply fundamental rights against the state, and now the legislature would decide what are the reasonable restrictions.
Other provisions of Part 3 were applied without any modification.
There is a modification.
35C is there.
35C, my lord. And that is more draconian, my lord, if I am permitted to say so. Because that directly affected the personal liberty of the entire population of Jammu and Kashmir.
Preventive detention.
Preventive detention. 21 and 22 would not apply. But it's unthinkable in any constitutionally governed civilized society that Article 21 and 22 would not apply. Please see, my lord, Article 35C was added. India's constitution was amended by the government of India in consultation with the state government, adding this sub-article. Lord, see, no law with respect to preventive detention made by the legislature of the state of Jammu and Kashmir, whether before or after the commencement of the Constitution Order 1954, shall be void on the ground that it is inconsistent with any of the provisions of this part, but any such law shall, to the extent of such inconsistency, cease to have effect on the expiration of 5 years from the commencement of the said order, except as respects things done or omitted to be done before. Well, this 5 years became 10 and thereafter it became 15. It continued till 1974. And my lord, most interesting part which I found.
Mr. Solicitor, you are appearing for the government of India, which did all this.
Yes, my lord, I'm saying.
In constitutional theory, the government of India is a perpetual entity.
Succession. My lord, the government of India has a right to say that this ought not to have been done and correct itself, which we did, and I'm justifying that correction. So I'm not saying that government and this government. It's our government.
Because in constitutional doctrine, the government of India is one perpetual entity.
Perpetual entity with perpetual succession, my lord. Yeah. And therefore, my lord, the justification, my lord, which I am trying to give is that the mistake of past should not befall on the future generations. And that's why what we did in those days, I am justifying, my lord, I am justifying our undoing it in 2019. Yes. My lord, one very interesting angle I found out, my lord, while researching this on this question. My lord, in Premnath Kaul, some person was, Mr. Kaul was, Premnath Kaul was detained under preventive detention law. He approached this honorable court under Article 32, challenging his detention. The learned Attorney General, then, my lord, appearing for the government, took the contention that 32 petition is not maintainable because it would lie only for violation of fundamental rights, and for Jammu and Kashmir, Article 21 and 22 are not fundamental rights. Fortunately, my lord, the court did not go into that question and decided it on merits. I'm sorry, Sampath Prakash, not Premnath. That was, my lord, the position of the 35C. Fundamental rights, your lordships have said 21, 22 is the heart and soul of the entire chapter 3. That was not applicable. It could be dispensed with while making a law for detention. Then, my lord, 35A was added. Please come to, my lord, page 56. And this, my lord, if we were to believe, resulted in several consequences. Please see 35A, amended in Constitution of India only to be applied in one state of Jammu and Kashmir. Please see, madam. One artificial class was created. Notwithstanding anything contained in this Constitution, that is Constitution of India, no existing law in force in the state of Jammu and Kashmir, and no law hereafter enacted by the legislature of the state defining the classes of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or conferring on such permanent residents any special rights and privileges, or imposing upon other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or right to scholarship and such other forms of aid of the state government may provide, shall be void on the ground that it is inconsistent or inconsistent with, or takes away or abridges any right conferred on the citizens of India by any provision of this part. A separate category of permanent residents was created, and any law which provides for this kind of special privileges would not be hit either by Article 14, Article 19, or any part of the Constitution. And that demarcating line from which date a person should be treated to be a permanent resident was, I think,
5A challenged on the ground that it violates the basic structure.
35A, it is, there are 5 petitions pending.
No, but that's, before that it was never challenged.
They were challenged at the relevant point of time, could never be decided. Since long. Lord, kindly see, my lord, the impact of this. The cutoff date was, my lord, I am told 1927. So whoever came in Jammu and Kashmir in 1927 were permanent.
That's the law. What is the provision itself? It says it's not, the judicial scrutiny is therefore prevented because.
Now the impact was, for example, people from Jammu and Kashmir, people from Pak-occupied Jammu and Kashmir, Pak-occupied Kashmir, POK, were driven out, both Hindus and Muslims. But they were driven out in 47 during those raids. They are not permanent residents. They were not permanent residents till 2019. There were large number of Safai Karmacharis who have filed a petition, my lord, or intervention application, who were brought from other states to do, my lord, the manual work of cleanliness, etc. They are not permanent residents. They are not getting any of these benefits. Despite living for decades together, no person, my lord, beyond outside Jammu and Kashmir can acquire property, meaning thereby no investment.